Good morning, everyone. Today I will be discussing with you about the salient features of the Child and Adolescent Labor Prohibition and Regulation Act 1986. So, to begin with, this act basically focuses upon certain objectives. So, we will be starting that what are the various objectives behind enactment of this law. So, basically, the first and foremost objective of this act is that this act prohibits the engagement of children in all occupation and processes. And this act prohibits the engagement of adolescent in hazardous occupation and processes and the matters connected therewith. And third objective of this act is that it regulates the condition of work of adolescent in non-hazardous occupation and processes. So meaning thereby, this act basically focuses upon three things. First of all, prohibition of engagement of children in all occupation and processes. Secondly, prohibiting the engagement of adolescent in hazardous occupation and processes. And thirdly, to regulate the conditions of work of adolescent in those occupation and processes where they are allowed to work. Now comes the applicability of this act. As far as the applicability of this act is concerned, this act applies to whole of India, and the provisions of this act shall come into force at once, but except part 3 of this act will be applied on such date as may be notified by the appropriate government and central government in this behalf. Now we will be discussing about the definitions of various terms which are used under this act. So first term which is defined under this act is adolescent. As per the definition of adolescent, adolescent means a person who has completed the age of 14 years, but who has not completed the age of 18 years. So meaning thereby a person, a minor who has completed the 14 years of age, but who is below the 18 years of age will be deemed to be an adolescent as per the provision of this act. Thereafter, they have also defined the definition of appropriate government under this act, which means in relation to that establishment which is under the control of central government or a railway administration or a major port or a mine or oil field, then the appropriate government will be central government. And in rest of the cases, the appropriate government will be the state government. And after that, they have also defined the meaning of child under the provisions of this act. So what we can say that according to this act, the child means a person who has not completed the age of 14 years. So to sum up, what we can say that the minor has been classified under this act in two categories. Number one is adolescent and number one is child. So child is that person who has not completed the age of 14 years, meaning thereby a person who is below the age of 14 years will be deemed to be the child, and a person who has completed the age of 14 years but who has not completed the age of 18 years will be deemed to be the adolescent as per the provision of this act. Thereafter, they have also defined the term day. So whenever the word day will come under the provisions of this act, it means a period of 24 hours beginning with the midnight. So day means a period of 24 hours which is beginning at the midnight. And they have also defined the term establishment, which includes shop, commercial establishment, workshop, farm, residential hotel, restaurant, eating house, theater, and other place of public amusement and entertainment will also be deemed to be the establishment. And another term which has been defined under the provision of this act is that of family. Family, wherever the word this family comes in relation to an occupier, means the individual, the husband, wife, or that individual, as the case may be, of such individual and their children, brother, sister of such individual. So family, whenever the word family in relation to occupier will come, then his spouse as well as his children, brother and sister will come within the periphery of this family. And thereafter, they have also defined the term occupier. Occupier in relation to an establishment or a workshop means a person who has the ultimate control over the affairs of establishment or work of that. And thereafter, they have also defined the term port authority means an authority which is administering a port, and they have mentioned the definition of week also under the provision of this act. They have mentioned the definition part that week means a period of 7 days which is beginning at midnight on Saturday night or on such other night as may be approved in writing for a particular area by the inspector. So what we can say that wherever the word week come, it will mean the period of 7 days, which will be starting at a midnight on the second night. That will be the term, meaning of the term week. Thereafter, they have also defined the term workshop. Workshop means any premises wherein an industrial process is being carried on, but it will not include those premises which are not covered within the definition of factory. So they have also defined the definition of premises. Now, another part, that is the part second of this act we will be studying. That part two or second of this act basically talks about certain prohibitions which has been mentioned under the provision of this act. So under this act, under section 3, they have mentioned the prohibition of employment of children in any occupation and processes. So this is the first prohibition which has been specified under the section 3, which says that under this act, any form of child labor has been completely prohibited, whether in any occupation and processes. But this prohibition has been subject to certain exceptions. So meaning thereby, under section 3, what they have specified, that child labor is completely prohibited. But this provision of prohibition has certain exception. According to this, under certain circumstances, child is allowed to be employed if he is helping his family or family enterprises, which is other than any hazardous occupation or processes, which has been mentioned in the schedule of this act, or where the child is working as an artist in any audio-visual entertainment industry, including advertisement, films, television, serials, etc. So in that situation also, child is also allowed to work except in circus, and provided that in no case his school education should be affected. So meaning thereby, under this act, what they have specified is that child labor is prohibited, but if child is helping his family or family enterprises, and that family or family enterprises are dealing with non-hazardous occupation processes, then he is allowed to work during his vacation or after his school hours. And in second situation where he is allowed to work is when he is working as an artist in any audio visual entertainment industry, but that does not include circus. But in no case, in both of these two categories, he is allowed to work if his school education will not be affected. So that is the exception to this prohibition, which talks about that it's the complete prohibition of child labor. And another provision which is provided under this act is mentioned under the provision of section 3.8, that talks about provision of employment of adolescent in certain hazardous occupation and processes. So under this act, what they have mentioned is that any adolescent will not be allowed or permitted to work in any hazardous occupation and processes which has been mentioned in the schedule of this act, provided that discretionary power has been given to the central government to specify the nature which will be categorized as non-hazardous occupation and processes. So what we can say that under this act, child labor is completely prohibited, but adolescent is allowed to work when he is working in non-hazardous occupation and processes. Thereafter, under section 4 of this act, they are talking about that what are the power and procedure to amend the schedule of this act. So section 4 and 5 talks about the procedure. We are aware that schedule of this act talks about certain categories of list of the hazardous occupation and processes and list of non-hazardous occupation and processes. From the schedule itself, we will be able to know that what type of activities will be termed as hazardous occupation and processes and what type of activity will not be termed as hazardous occupation and processes. So under section 4, they have mentioned that central government has been given power under the provision of this act that after giving 3 months notice period in official gazette, it can add or omit any hazardous occupation or process from the schedule of this code. So government has been empowered to add or delete any item as a hazardous occupation and processes. And apart from this, under Section 5, a technical advisory committee will be constituted by the central government for the purpose of adding of occupation and processes to the schedule of this act. And this technical advisory committee will be composing of chairman and other members not exceeding 10 in number. Thereafter comes the part 3 of this act. Part 3 of this act basically talks about regulation of conditions of work of adolescent, which are specified from section 6 to section 30. So section 6 basically talks about application of this part. So this part 3 talks about what rules and regulations or conditions are to be observed whenever an employer is employing any adolescent in his premises. So this part 3 will be applicable to those occupation and processes which are non-hazardous in nature, because we are aware that adolescent will be allowed to work in only those occupation and processes which are non-hazardous in nature. So section 7 will come into picture. Section 7 basically talks about hours and period of work. So section 7 says that no child, no adolescent shall be allowed to work for more than 6 hours in a day. So here 6 hours is the maximum limit time period for which we can employ an adolescent in the premises of the employer. But they have also specified that this 6 hours of work period shall include the time spent in waiting for the work on that particular day. And no period of work on each day shall exceed 3 hours at a stretch. So whenever any employer is employing an adolescent in his premises, then he has to take care of this fact, that this rules, that he shall not employ an adolescent for more than 6 hours a day, and these 6 hours include the time spent in waiting for a work to be done by the adolescent. And in no case he shall be allowed to work at a stretch for beyond 3 hours. So after 3 hours, minimum time period of 1 hour of rest period will be given to the adolescent. And he is also not allowed to work between 7 p.m. to 8 a.m. He will not be allowed to work for overtime, and he will not be allowed to work in an establishment on any day on which he had already worked in any other establishment. So these are the certain regulations which has been specified under section 7 of this act. Thereafter, they have also specified the weekly holidays should be given to the adolescent a whole day in a week. So what does section 8 talks about? That every adolescent shall be allowed for a holiday of a whole day in a week. So that is also important provision which has to be followed by the employer whenever he is employing an adolescent. And apart from this, section 9 talks about that notice to the inspector has to be given whenever any employer is employing an adolescent. Then he has to specify to the inspector through notice the name and situation of the establishment, name of a person, and nature of work which is being done or carried on by the adolescent. So all those facts has to be specified by the employer in the form of notice, and this information has to be given to the inspector by the employer. Thereafter comes section 12. Section 12 talks about that display of notice containing extract of section 3A and section 14 has to be displayed by the employer in the conspicuous part of his premises. Thereafter, section 14 talks about penalties. So if any employer contravene with the provision of this act, in that situation, he will be punishable with imprisonment for term minimum 6 months up to 2 years, or fine minimum 20,000 up to 50,000 of rupees, or both of them can be imposed if he is employing any child or any adolescent in contravention with the provision of this act. And under this act, they have also specified that in case a guardian of a minor or guardian of a child or adolescent is held guilty under the provision of this act, then first time offender will not be punished. So that is the exception which has been given under section 14, that these parents and guardians of a child or adolescent will be exempted from the punishment if they are committing this offense for the very first time. But if subsequently they commit a repetitive offense under the provision of this act, then they will be punishable with a fine up to 10,000 rupees. So that is the penalty which has been prescribed for the parents. And in case of repetitive offender, the imprisonment of minimum 1 year up to 2 years can be imposed upon the person. And another thing which has been specified under section 14A is that offenses under this act which are mentioned under section, which are in contravention of section 3 and section 3A will be cognizable offense. And in every district or two or more districts, there shall be constituted a child and adolescent labor rehabilitation fund, which should be established by the central government. And they have also mentioned under section 14D that compounding of the offences, that district magistrate on the application of the accused person can compound any offence which is committed for the very first time by him under section 3 and section 14. If he fails to follow the rules and provision of this act, then he can be this offence can be compounded by the district magistrate. And then after section 16 comes that procedure relating to offences. So if any offence has been committed under the provision of this act, in that situation, any person, inspector, police officer can file a complaint for the court who is having jurisdiction. And here, under this act, magistrate of first class or metropolitan magistrate will be the authority who will be dealing with this such type of cases. And certificate which will be issued by the prescribed medical authority as to the dispute regarding the age of a child will be the conclusive evidence of his age. So that is the thing which they have specified under section 16. And thereafter comes section 17. Section 17 basically talks about the appointment of inspectors. So appropriate government has been empowered to appoint inspectors under the provision of this act for the purpose of inspecting whether the provision of this act are being followed or not. And inspection and monitoring shall be done by the appropriate government under section 17B. And under section 18, they have mentioned that powers of appropriate government to make rules to carry out effectively the provision of this act so that this act may be properly followed within the territory of India. So with this, we had completed our topic with regard to salient features of the Child and Adolescent Labor Prohibition and Regulation Act. I hope you have understood this topic clearly. Thank you so much.